Hello and welcome to the year 2018. 2018 was declared by our man of God, Reverend Dr. Chris Uyahilome, as the year of the supernatural. And this is the courthouse. I am Itohan Olomu-Agbodo. The courthouse is all about the law. We learn the law in plain, simple, and entertaining language. And I promise you that this year, this season, is going to be indeed supernatural. We'll take a break, and when we return, we'll let you know more. Stay with us.
Global Plus app is bigger and better. Watch all our shows with just a click.
Let him have the right to decide what happens with your body.
Watch inspiring, informative, and entertaining programs. You can comment, like, and share. Watch our live TV and web TV on your mobile devices. Watch the big stories in real time or when you have the time. Experience Lovell Plus app right now. Download Lovell Plus app on Android, iOS, and BlackBerry. Go to Google Play Store, Apple App Store, or Windows Phone Store. Welcome to the bigger picture. Lovell Plus, beyond television.
You're welcome back. If you're just joining us, this is our first episode of the year 2018, and we're going to be talking about enforcement of court judgments. Basically, a judgment is a decision reached by a court of law. And I am not here alone. I have with me Barrister Kamios Omosiwe, managing partner of Glenville Solicitors, a firm of legal practitioners. I'm so honored to have you here, sir.
Thank you very much. I'm equally very honored. Happy New Year to everyone.
Yes, sir. So this year, it's going to be great and supernatural indeed. But now we're looking at court judgments and how to enforce judgment. But first of all, in your opinion, what is a court judgment?
Well, a court judgment is the outcome of any matter that was referred to the court for adjudication. Normally, you know that in ancient times, we have what is called the rule of might, the survival of the fittest.
Yeah.
The stronger person will normally dominate the weaker one. But as society evolved into civilization, rules, regulations, and structures were put in place. And if you put these things in place, there must be a system or a structure equally put in place to be able to determine if anyone breaches any of these rules.
Okay.
And that's what the court is meant for. Now, when a party feels aggrieved, or a party thinks that there's a right that he has that is about to be infringed, he can approach the court for the determination of that right or for remedies for that, for such infringements. Now, when the court goes through the process, whether it's an arbitration, whether it's a tribunal, whether it's a regular court, once they go through the process of adjudicating with the view to determining the existence of such rights or whether a wrong has been done to a particular person, the outcome, the decision reached, is what we refer to as a judgment in that case.
Okay, the decision reached by the
Yes.
court. Yes, that is a court judgment. And now we hear about several types of judgments. For instance, I've heard about consent judgments and the like. For the benefit of our viewers, we'd like to know some of the types of judgments.
Well, let's start with the one you just mentioned, consent judgment. Normally, the courts will employ people or encourage people, even though you've already come into court, to meet to see how you can resolve matters amicably, rather than wait for the process to spend itself out and then the court gives its judgment. So when parties meet in the course of a judicial proceedings and then they make compromises and they write their own judgment, what they think is satisfactory to both parties, and they move this, they file this process in court for the court to make pronouncements on those terms as the judgment of the court will. And once the court does that, it then becomes a consent judgment, which means a judgment that was reached based on the consent of the parties after possibly meeting, out of court to resolve the matter.
Okay, so now these parties have met and they've resolved the matter and they've brought their own decision to the court. So does that have the same force as any judgment reached by the court itself?
Oh, yes. Once the court makes pronouncement on it, it becomes binding on the parties. It's taken as though it was the judgment that emanated from the court. It becomes a court judgment upon the parties, and you can't go against it. once the
go
court has
against
made pronouncement on it.
Okay, so it therefore means that you can also go on appeal if there's any breach or if you're not satisfied. Is there anything like that? Because there's consent here.
Exactly. You can go on appeal. You can, but of course, you can even ask for the court to reverse it, but you need to seek the leave of the court. And you find that in very sparse situation because both of you met, you went through a process, and then, of course, you agreed on what you thought should be adequate in the circumstance. So why split hairs over that after the judgment has been given?
Okay.
So it's largely your consensual view of how you want the matter to be resolved. And so the court takes it and then determines that as the judgment of the court in that circumstance. So you hardly have people who would then go against it because, of course, you didn't do it under duress. It's an out-of-court meeting you had to resolve the matter amicably. So you hardly find people who go against it. But, of course, in rare cases, you find that. So because the court thinks that it's your decision, then you will need to seek the leave of the court to go against that judgment.
Okay. By leave, you mean permission of the court?
Yes, by permission of the
because
court.
I've heard somewhere that
Yes.
lawyers seek leave, they don't seek permission. All right,
Yes.
so now we've talked about consent judgments.
Yes.
Any other type of judgment we need to know about?
Well, you have, we're looking at enforcement of judgment, but there are certain kinds of judgment that you don't need to enforce.
Okay.
For instance, you have declaratory relief, declaratory judgments.
Okay.
Now, declaratory judgment simplicity means that you are trying to declare the existence of a right without more.
Okay.
For instance, somebody saying, please, I am 15 years old. Let the court determine whether I have a right to enter Unilag as a student in university.
Okay.
Right?
Yes.
Of course, the court may go ahead and pronounce that you have the right or you don't have the right. I understand that the minimum entry point for Unilag and Federal University is 16 years. So if you are 15 years and then you think that you want to try out, you can go and then try to determine whether you have a right. Now, if the court determines that you have a right, right, without more, there's nothing to enforce.
Okay.
You understand? We've not come, but that is a declaratory relief. The court has declared.
Just a statement.
Yes, that yes, you have a right.
Okay.
You see, but when we come to the issue of enforcement of court judgment, we'll look at the weight that carries with respect to enforcement. Then there are executory judgments as well. Judgment that have specific terms that the court is requiring a party to do specific things.
Okay.
Of course, you can enforce such judgment.
Interesting. So we have consent judgments, we have declaratory judgments, and we have executory judgments.
Yes.
Okay, we'll take a listen to our reports and some of our legal nuggets, and we'll be back with more on this topic. Stay with us.
In law, a judgment is a decision of a court regarding the rights and liabilities of parties in a legal action or proceeding. Judgments also generally provide the court's explanation of why it has chosen to make a particular court order. The phrase reasons for judgment is often used interchangeably with judgment, although the former refers to the court's justification of its judgment, while the latter refers to the final court order regarding the rights and liabilities of the parties. As the main legal systems of the world recognize either a common law, statutory, or constitutional duty to provide reasons for a judgment, drawing a distinction between judgment and reasons for judgment may be unnecessary in most circumstances. Types of judgments can be distinguished on a number of grounds, including the procedures the parties must follow to obtain the judgment, the issues the court will consider before rendering the judgment, and the effect of the judgment. Judgments that vary from a standard judgment on the merits of a case include the following. Consent judgment. Consent judgment is also referred to as an agreed judgment. A consent judgment is a settlement agreed upon by the parties and authorized by a judge. Declaratory judgment. This is a judgment that determines the rights and liabilities of the parties without enforcing a judgment or otherwise requiring the parties to do anything. A declaratory judgment may be useful where the parties have differing views about their rights and duties or are wishing to clarify them without seeking any other remedy. Default judgment. A default judgment is a judgment rendered in favor of one party based on the other party's failure to take action. Default judgments are commonly used where the defendant fails to appear before the court or submit a defense after being summoned. A default judgment grants the relief requested by the appearing party and does not require extensive factual or legal analysis from the court. Interlocutory judgment. This is an intermediate or interim judgment providing a temporary decision on an issue that requires timely action. Interlocutory orders are not final and may either not be subject to appeal or may follow a different appeal procedure than other kinds of judgments. Reserved judgment. A reserved judgment is that which is not given immediately after the conclusion of the hearing or trial. A reserved judgment may be released days, weeks, or even months after the hearing. In the United States, a reserved judgment is sometimes annotated in law reports by the Latin phrase cor ad fault or CAV, Curia Adversaria Fault. That is, the court wishes to be advised.
You're welcome back. If you're just joining us, this is the courthouse where we learn the law in plain, simple, and entertaining language. And my guest today is Barrister Camius Omosiwe, who's been telling us about various types of judgments, explaining the concepts of judgments of a court, a declaration made by a court. We've talked about consent judgment, declaratory judgments, executory judgments. And now we're going to be looking at the issue of enforcement of judgments. How are judgments of courts enforced? We hear of beliefs, we hear of this and that, but just give us a general overview.
Of course, the court has a right to safeguard its judgment. Okay. Because if you give a judgment that is unenforceable, we say equity does not act in vain. Okay. Of what purpose would be the judicial system then? You see, so when the court gives its judgment, remember, in the process of initiating an action to the point of the court handing down its judgment, you have various interlocutory decisions, if you like. They may bring in this interlocutory application in between, and then the court will have to decide on such decisions. Okay. Yes. Now, these are not there. There's no tone of finality in these. When we're talking about judgment, there's a tone of finality when we're talking about judgment. Normally, the law and society expect that once judgment is given with specific terms of performance, the judgment debtor ordinarily ought to respond to that judgment, understanding the nature of the institution that handed down that judgment. But you see, not in all cases. In some cases, you find people who become deviants or recalcitrants to responding to the judgment of courts. And so once you find that situation, because the judgment creditor here means the victorious party with respect to that judgment, and the judgment debtor means the party who has a liability flowing from that judgment. Now, once the judgment debtor fails to respond, let's give an instance. For instance, someone took another party to court, insisting that the party is indebted to him to the tune of 20 million naira. And then the court agrees and said, you are indebted to party A to the tune of 20 million. Okay. Party A becomes the judgment creditor, party B becomes the judgment debtor. Now, in normal situations, society expects that party B would take steps to honor that judgment and by going to pay the money. But sometimes they sit aloof and they don't do anything. Once you find a situation like that, society does not expect that anyone will take the laws into his hands. Self-help is abhorred. So the judgment creditor doesn't need to take the judgment and go and start fighting. Okay. So he approaches the court again. The process of enforcement of this judgment is also called the execution of this judgment. He has to go back to the court to seek the structures, to try to deploy the structures already put in place by the court to enforce that judgment. So he can't do that on his own.
Can't do that on your own.
Yes. So you have various kinds of action that you need to take at this, on this instance based on the nature of the judgment. If it's a money judgment, for instance, you go to the court and then you can apply for what we call the writ of fife.
Writ of fife.
Yes. The writ of fife will give you the authority to go after the goods or chattel of the judgment debtor.
That's simplicity. The
properties of the judgment debtor,
yes.
With the aid of court officials, either sheriff, deputy sheriff, or bailiffs, as the case may be. Now, of course, normally they seek the aid of the police to work with them.
Okay.
Now, once they get in there, they will then impound and seize the properties of the judgment debtor and move this property where they are movable to the court premises, and then they are sold by auction. And so you can recoup your money.
Okay.
If it's more than the money that you are indebted to, then you leave the outstanding, the balance money in court, so they can come to court and collect
Wow,
it.
quite interesting there. So
Yeah.
even after a judgment is reached by the courts,
Oh, yes.
some people have the tendency not to obey court judgments.
Oh, yes.
And it's quite rampant. There's this recent protest in Abuja, the Federal Capital Territory in
Yes.
Nigeria, where people in the Apple settlements, they were protesting that we got judgments and the court said this is our land, we're supposed to go back to the land, and they are being deprived or something like that. Can you give us an insight into that case?
Well, it's a conspicuous case, a popular case. Now, they are dealing with the government.
Yes.
You understand? They are dealing with the government. If you were dealing with an individual, it would then have been much easier, because you will take these steps that I'm talking about now. We will not even through with the one for money, because that's not the
Yes.
only step that you can take. But in this instance, because the government is involved, right? How do you want to go and levy execution of government properties? Where do you want to go and take the execution of government properties?
Because the court itself is even government property.
Exactly. So you then go through the Attorney General.
Okay.
If it's a federal structure, if it's a state structure, you go through the Attorney General of the state, or the Attorney General of the Federation if it's a federal structure. You give them a copy, a certified true copy of the judgment. And then, of course, we expect that the government, the executive arm of government, will willy-nilly respond to judgment of court. But of course, we've seen several instances where they refuse to heed, to judgment of court. The Sambo Dasuki's case is a point in view when they refuse to grant bail even after the court has pronounced bail.
So what does the citizen do now? I've gotten judgments against the government and I can't fight the government, but what do I do?
Well, it gives a negative political undertone. So that people use the press pressure against the government, because every structure you want to use for enforcement, they're all government structures. And so when it comes to the executive, and if an executive becomes recalcitrant to court orders, then of course the society becomes helpless, because they are the ones who should be the shining light and the beacon to obedience of court order. But sometimes in third world countries and some African countries, you find situations where they are the biggest detractors to this truism.
Okay, so we keep calling for reform and using the press to put pressure on the government to do what is right. Interesting.
But when it has to do with citizens, corporates, artificials, then of course we say there's no respecter of the law.
Okay, so now looking at this situation of enforcement of judgment, I know there are a lot of things that you'd like to tell us, but by way of summary, can you just give us a...
Well, I've just talked about one where you apply for the writ of fife, and of course, if it's a money judgment, you can equally embark on what we call the garnishee proceedings as well. And I think that is tidier, where you go after institutions that warehouse the finances of the judgment debtor, maybe banks. Sometimes you may not even know the particular bank. Then you can bring a speculative action on maybe about 12, 15 banks, right? And then you sue them to come and show cause. Now, once they receive the garnishee order nisi, the court compels them to disclose whether the judgment debtor has or maintains account with any of them. And then they swear to an affidavit before the court to say, yes, he has an account with us. This is the amount of money in that account. If the amount of money can satisfy the judgment debt, even if it cannot, the court will say, look, pay the judgment creditor. But if it can, good for the judgment creditor. The garnishee order NISA will then be made absolute, and then he will then pay the judgment creditor.
All right,
and then once there's no money there, then they will be discharged.
They'll be discharged.
But alternatively, or you can equally deploy the contempt proceedings against a judgment debtor. Once you know that the man has, we usually say that a debtor is not a criminal, right? But there are situations where it can then be translated into quasi-criminal activity. Because if the court gives an order asking the judgment debtor to pay the judgment creditor a certain amount of money, and the judgment debtor defaults, and you are very sure that this man has the money, you can bring a contempt proceeding against him for disobedience of that court order. And I think they run away from that because if you're not careful, you can find yourself in prison for disobeying court order.
Quite interesting. Any last words?
Well, there's a plethora. We'll just scratch the surface. We have different aspects for recovery of possession, different where, for instance, you have gotten judgment to gain possession, but you didn't have the requisite order for force open. To force open the apartment.
So that will lead us to self-help, and I would like us to take self-help separately. Thank God you're saying it now.
Thank you.
You're going to be our guest on that episode when we'll be talking about self-help. Thank you, because I know you vibrate.
Thank you.
So now we are going to our Bar Book segment. Bar Book is where we share Latin maxims. I know you know a lot of Latin maxims. You've thrown a lot of them at us right now. But I will just stick with one that you raised. You talked about contempt of court. So I'll stick with contempt ex facie curia or contempt in facie curia, contempt in the face of the court or contempt outside the court. You talked about garnishee NISA and garnishee absolute.
Absolutely, yes.
So can you tell us a minute?
Garnishee NISA is an interim, a temporary order given by the court for the bank or the financial institution or anyone who is warehousing the finance of any particular party to come and show cause why he should not remit that money to the judgment creditor. Now, once it comes to show that, yes, this man has the money and there are no extenuating circumstance, the court then makes that NISA absolute, which is in finality, and then compels the warehouser of that particular fund to release the fund to the judgment creditor.
Interesting. Latin is actually a very interesting language, and it is a language of the law. So you get to find out more Latin maxims on our Bar Book segment. Stay with us. You're welcome back. This is still the courthouse, and Barrister Camios talked about enforcement of court judgment with us today, gave us interesting insights into that topic. I must say thank you so much for making our time to be with us on the show today.
Thank you. I appreciate it.
And we have another episode, more episodes in this year of the Supernatural. Thank you so much, sir.
Thank you.
We have our question and answer segment. You sent questions and we provided answers to them. Take a listen.
It's so necessary to throw light on the issue of self-help, because there's a common complaint of that. It seems to be so prevalent. Personally, I get reports of landlords resorting to self-help very, very often. It is very, very wrong that, as I started, even if you have served the statutory notices and the tenant refuses to budge, the law does not enable you, just by virtue of statutory notices, to enter the premises and start throwing things out. All those rights that the tenant would have had, assuming you never terminated the tenancy with the statutory notices, he still has it. The right against trespass. You cannot act without the backing of the law. Yes, you have set the machinery in motion by serving him with a quit notice and the notice of intention to recover premises, but then you are not to go get thugs and then start removing his things. You incur damages for trespass. The right to dignity of human person is there because you didn't follow the procedure of the law. The right to privacy is there because you didn't follow the procedure of the law. So that is self-help. The law enjoins you to approach the court and get an order so that there will be legal backing for what you are doing.
I hope we were able to answer some of those questions you sent in to us. We would like those questions to keep coming in. If you have questions for us, we have comments. We would like you to send your comments, your questions to the numbers that will be showing on your screen now. We'd also like you to log on to our website on www.loveworld+org. And I would love you to download our app, Love World Plus, on any of the mobile app stores. And I am Itohan Olomu-Agbodo. You know, if you've gotten a judgment, you still don't have to get mad. Go get a lawyer. Bye for now.